Welcome back. In Brunswick, Georgia, jury selection enters its third week for the 3 men accused of killing Ahmaud Arbery. As of Friday, 55 jurors have qualified. 9 more potential jurors are needed in order for the court to move on to the next steps, finding a final panel of 12 and 4 alternates to serve in this trial. It has been a slow process as 3 defense teams and the state have been challenging potential jurors and whittling them down, trying to find out if they're impartial, unbiased, what they know about this case. Court TV legal correspondent Julia Janae is outside the Brunswick, Georgia courthouse with the very latest on jury selection. Julia.
Opening statements at this point are imminent. We are only 9 jurors away from having the qualified pool that the court wants before these lawyers get to use their peremptory strikes. On Friday, there were an additional 8 potential jurors who were selected. 5 of them from the actual pool that came in that day, and then the court went back to day 1 and heard arguments on those jurors, so playing some catch up and then adding another 3 potential jurors who were qualified, including one woman who said she may have a daycare issue if court doesn't wrap up at 5:30, but the judge said he doesn't think that's a problem. Asked these parties if they have an issue with it to get him some case law to explain why he cannot sit her as a qualified juror. On Friday, there were a lot of issues that came out of that individual questioning, including some digging into the faith of these potential jurors, asking them about their church denomination, which raised some criticism from some of the supporters who are outside of this courthouse. The Transformative Justice Coalition calling for that to be considered an irrelevant question, but it has been one that we've heard a lot of from Kevin Goff, the attorney for William Roddy Bryant. 90% of the time, that's one of his first questions of these potential jurors once they pass into individual questioning. He also raised on Friday the idea that there's an unrepresented group in this panel of 55 that we have so far. Here's a bit of what he had to say.
No one's being struck because you're black.
Not at all?
Well, no. No, I can say that without reservation. This is a very diverse pool of jurors. I expect that the panel will be a diverse pool of jurors.
Also during arguments, Goff said that the master list for the court that lists the race of these potential jurors is missing information. So he's also asking for that to be updated. Sitting through this jury selection process has also been the parents of Ahmaud Arbery. There are times when Marcus Arbery is inside, and also Wanda Cooper Jones, who we were able to speak with and ask about why she felt it was important to even be here for this part of the process. And she talked about exactly what she looks for when she is inside and what she is hearing from those potential jurors as they're being questioned.
I had a juror come up and she was talking about what she had heard from the media, and she went on to describe the clipping of the video where Ahmaud was taking his last breath, and that was very disturbing. I often look over at them when the jurors come in and say that they're guilty, just to see, can I get a response, like a response off of their face. Often I do that. Sitting in court every day, I haven't seen any kind of remorse at all. It's just that they're there, they think that they hadn't done anything wrong, and it's going to be up to the courts to decide that.
What we're still waiting on learning is once we do have a pool of 64, whether or not the court is going to make them all come into this courthouse behind me, which the judge has said would be really logistically difficult, or if they will do the strikes without those potential jurors and then send them a summons reminding them that they are part of this 16 jury panel. Reporting in Brunswick, Georgia, Julia Janae with Court TV.
All right, our thanks to Julia. Still with us, former prosecutor, former assistant state attorney Sue Ann Robinson, now works for the Ben Crump Law Firm. She's in Fort Lauderdale, Florida. So this one, Sue Ann, much different than what they're predicting up in Wisconsin 1 or 2 days. Now we're into week 3. Big part of that is the 3 defendants and their 3 defense teams. It's adding necessary time. Your thoughts on the process overall, where we are so far, and the difficulties of just the situation, small county, high-profile case, 3 defendants.
Yeah, I mean, at this point, they're cooking with gas. We're getting closer. The issue is, you're exactly right. It's a very high-profile case, in a small area. It wasn't moved out of the venue, wasn't changed. So these are all people that are very familiar, not just with possibly the defendants and the case, but even with the inner workings, the clerk's office, the sheriff's office, all the players in the town that are involved in the case or have evidence in the case are people who are also in the jury pool. So they're trying to get qualified jurors seated so that the defense and the prosecution have their opportunity to use their strikes. And I think the judge has been, very, I don't know if the term lenient is appropriate, but in terms of qualified jurors, he has allowed people into the qualified jury pool that I think personally may or may not have been appropriate at times, but he's done it on both sides. And I think his goal is to get to that 64 and then allow the attorneys, the defense attorneys to defend and the prosecution to prosecute in terms of deselecting the jurors that they think are going to be unfair. And to be honest with you, it has been a long process, because there are 3 defendants, because there is so much at stake, because it's such a high-profile case. I think that they are giving the time that is appropriate.
One of those defendants is Roddy Bryant, and his attorney is Kevin Goff. And Kevin Goff has been very vocal about some of the issues during this jury selection process. And one of the things he brought up at the end of last week was the fact that he's a little concerned that there's a segment of the population that is underrepresented, possibly, and the way he describes them are white Southern men, and he goes on to call them, like Joe Sixpack or Bubba. Take a listen.
In this case, it would appear that white males born in the South over 40 years of age without a 4-year college degree, sometimes euphemistically known as Bubba or Joe Sixpack, seem to be significantly underrepresented. I can't say underrepresented in the entire panel of jurors because the race information on the master list is obviously not inaccurate. Also, that list is missing crucial information to identifying this group. So there are 2 issues. The one issue is whether that is a cognizable class. If it's not a cognizable class, then that's really the end of the discussion. If it is a cognizable class, then figuring out what the appropriate evidence would be and what the standard would be is much less settled. As I understand it, to be a cognizable group for constitutional purposes, there must be some quality or attribute in existence which defines or limits the membership of that group. Second, there must be a cohesiveness of attitudes, ideas, or experiences which serve to distinguish the purported group from the general social milieu. Third, a community of interest present in the group may not be represented by other segments of the population. With all due respect, and without meaning to be stereotypical in any way, I do think there's a real question in this case, whether that demographic is underrepresented in this jury pool. And if it is, then we have a problem with it.
So, Ann, is he describing racist white guys?
Goff is doing way too much. I think he needs to focus more on his client, on the facts of his case, what he's going to say in opening. He has been making arguments that even the court is like, counsel, when you have an actual legal basis for whatever it is you're asking the court or motioning the court, let me know. He's been complaining about people singing outside. He said that he had an issue with people having banners, people having buttons, attorneys that aren't even on the case, their social media. I just think he is scattered in terms of his thought process right now. And I'm really hoping, just for the sake of his client, that he can find the time to sit down and focus. Him arguing that there's an underrepresented group that he's describing as Joe Sixpack. I mean, if the other attorneys on the defense side face when he's making these arguments, says it all. They're just literally sitting there like, what are you saying? What are you doing? Because the issue at this point is for them to find fair and impartial jurors that can look at the facts of this case and apply the law, period. Not him experimenting on a new class of people that are underrepresented in this particular case. He's doing too much, and he needs to focus more on the facts of his case and his client.
Barbara Arnwine is with the Transformative Justice Coalition. She says that this process is getting a little bit too much, saying that they're dragging their feet. Take a listen.
They're dragging their feet. I mean, I think this church question is ridiculous. I don't know why they keep allowing it. And then today he even asked what denomination. I mean, come on. I mean, this is just, there's a lot of irrelevancy going on in this court. And if they would stay on the relevant questions, focus on the ones that make sense from each side, I think we could get to a jury. But right now, this is just dragging. It's dragging. And a lot of it's because of the irrelevant questions. This is frustrating. It's not, you know, I know that they are distressed. And remember, a lot of their distress is coming from the questionnaires. It's, you know, what people said on their questionnaires. And when I say they, the defense, are clearly distressed. But at the same time, they're playing around with irrelevancies. There was another question, if you heard it today, about did you see protesters? How do you feel about all the protesting? Really? I mean, again, it's just, you know, their attention is not on getting to the trying of this case. Their attention is on irrelevancies, distractions, blame anybody you can but your own clients.
Sue Ann, the judge in this case, Judge Walmsley, he is allowing this to play out a certain way. And let's face it, appellate courts focusing on juries and jurors more than really anything else. Isn't it? I mean, yes, it's painful for all of the parties, including those potential jurors, but in the grand scheme of things, taking the time now is important.
Yes, I agree. And I think that the judge is doing the very, very best that he can. Goff, at points in the jury selection, is very confrontational with jurors, especially with his line of questioning with respect to their religious affiliation. And this jury is very informed on the facts of the case based on what they've seen, but they're also empowered in the process and understand kind of what their purpose is and are being very vocal in responding to questions. And so at times the court has even had to tell Goff to change his tone or pay attention to his tone, because it becomes very confrontational, almost like a cross-examination, with Goff asking questions, the prosecution doing rebuttal questions, and then Goff coming back in individual questioning, and the court having to remind the defense attorney, hey, listen, these are civilians who have come in to do their civic duty. They're not being cross-examined. They're simply being qualified to become prospective jurors, and you can strike them if you have a reason, a race-neutral reason to strike them. But the fact that the court has had to go that far in terms of advising him, you know, watch your tone, these are civilians that are just doing their civic duty, really says a lot about the tension in the process. And this is someone who initially, if you recall, said, hey, just give me the first 12 people, it's fine. So for him to go from that to now be so honed in on slight details, people's religious affiliation, is an interesting change.
Yeah, that's good. I forgot about that. Yeah, right away when this first blew up, he said, let's go, line them up, take the first 12. Big difference in what we're seeing now as we get into week 3.